Florida estate lawyers and probate litigation involving contesting a Florida will. Hello, my name is John P.L.L.C. and I'm going to be speaking to you today, May 18th, 2016, about a Florida probate rule involving the petition to revoke probate, what most Florida probate attorneys think of as the Florida probate rule that starts the ball rolling to contest a will. I'm also going to be speaking to you about a recent Texas case involving a will contest. It's dated April 26, 2016. It's on appeal from the probate court, and it is the Valdez versus Robinson case. The Westlaw site is 2016 WL 1644550. Why am I talking about a Texas case? Well, if you're involved in an inheritance lawsuit in Florida, or you're in the middle of probate litigation, whether you're in Collier County, Naples, Hillsborough County, Tampa, St. Pete, or Boca Raton or Delray, you might want to know what's going on in other states. You may want to read about your Florida estate lawsuit and get some other perspective. This is a cutting-edge, very timely case out of Texas that involved the death of a mother in 2008, 12 children, and the attempt to have a 1997 will admitted to probate, and in the alternative to have a 1988 will admitted to probate. And what was interesting about this Texas case was you had a number of people who were beneficiaries under the different wills, and you had a standing issue. Who could participate in, who could contest the will, who could participate in the estate proceeding to attack the will or file or participate in the will contest. And the Texas court used the buzzword that we Florida probate lawyers know and use often when we have a Florida probate trial or an estate or an inheritance lawsuit, an interested person, right? To be involved in a Florida probate, you have to be an interested person. You have to show some connection or nexus or some legal right, some legal standing to participate in the probate. And that seems to make sense, right? If you're having any legal proceeding, somebody shouldn't just be able to come in off the street and start filing court documents and arguing with counsel or before a judge, right? They need some connection to the underlying dispute. And in our case, we're talking about a connection to the decedent, a deceased person, or a Florida probate or a Florida estate. In the Texas case, in grappling with who has legal standing to participate in the will contest, who is an interested person, they looked at 4 parcels of real estate that was worth just shy of $1 million, about $800,000. That was an estimated value. And evidently deeded at a time when the person who signed the deed, the mom, may or may not have had capacity, because the deeds we read in this opinion were later overturned, right? So the question becomes, if a deed is overturned because it was improper or somebody lacked capacity in a period of time when a will may have been signed, Florida probate attorneys or estate lawyers are going to wonder whether the will is invalid as well. So in Florida, the context for a will contest typically begins with the Florida probate rules, and you can read these rules online free of charge by doing a Google search. Ask any Florida estate attorney and they'll tell you that Rule 5.270 is entitled Revocation of Probate. If there's a probate going and you want to contest the will or object to the will, you typically file a petition to revoke probate, and Florida Probate Rule 5.270 is the starting point. You can also look at the burden of proof in will contest in the next Florida probate rule, Rule 5.275. So you can find out about the procedures and burden of proof in the Florida Probate Code, or you can ask your Florida estate attorney about what you need to do to contest a will or overturn a will in a Florida inheritance lawsuit. By the same token, if you're the personal representative named in a will of a Florida estate, or you're a beneficiary, maybe you inherit the residuary clause, or you inherit the residue of one's estate, or you're a large beneficiary, such as a 25% or 50% beneficiary of a Florida will or a Florida estate or probate, you may want to get involved and defend that will and support that will and fight the person who's trying to obtain legal standing to come in and file a petition to revoke probate or to contest the will. Either way, you need a probate litigation strategy, you need a trial strategy, and it should be based on procedure, the rules, the law, and the particular facts and circumstances of your probate case. My name is John P.L.L.C. I'm a Florida estate litigation attorney with the P.L.L.C. Law Firm in West Palm Beach. This concludes my remarks about Florida estate litigation.